But when we plan for incapacity, the things that we need to look at is that it can happen to anybody. It's not something that's just a few people will experience. It can happen to anybody. Additionally, if we're failing to plan, it means that the court will make choices for us. We have a society that's built up that if we can't make a decision, society will make that decision for us, and that's usually through the court system, which can be good, but it can also be bad. A lack of planning, it also increases the burden on your loved ones. So keep that in mind. If you're not planning, you're still making a decision. It's just probably not the best decision. The other thing to keep in mind is your loved ones might not have the same idea that you have, and so they may choose something else, and it may not be in line with yours. If you have a plan in place, they know exactly what you want. Now that gets into these things. So when we talk about healthcare directives, we've got what's called a living will, a durable power of attorney for healthcare, and a do not resuscitate order. Now what each one of these are is a living will. It puts your instructions in writing. It says this is what I want to have happen if I'm incapacitated. The durable power of attorney lets you designate an agent to make decisions on your behalf. So that could be a child, it could be a spouse, it could be whoever you want. Someone you trust. The other thing that you should have in that file is a do not resuscitate order if you choose that. If you would like them to use any and all expense to keep you alive, make sure you let them know that in the living will. But if you don't, if you would prefer to say, you know what, at this point, if I'm not recovering, I want to make sure that we're not expending resources for it. And that's important to have because your idea may not be the same idea that the guardian has. And if it goes through the court and you get a guardian appointed and you have not done any of this planning, they may do something that's opposite to what you wanted.
It also helps resolve any family conflict because if you got
Absolutely.
2 or 3 or 4 kids, one of them will probably think, let mom or dad die peacefully. The other 2 will be like, no, they need to hold on as long as possible.
Mm-hmm.
I think they have a chance. So if mom or dad has previously written down what to do, then it takes the guesswork out of it for the kids. So
Absolutely.
You don't put that burden on them like you'd mentioned.
No, absolutely. You're exactly right. Now, this is similar when we get into property management tools. Again, this helps alleviate all of that family conflict. And here you can title things. So for instance, if you joint own things, then a joint owner has the same access to the property that you have. And when I say property, it's not just real estate property. I know people, when they hear property, they're thinking the farm. But the reality is it's all property that you own. And so if your house is titled jointly, then that joint owner has access to the house just like you do. Durable power of attorney, that again gives you an agent who can make decisions on your behalf. And so you want to consider who that's going to be. It's always a good idea to have that. The other thing to keep in mind with the durable power of attorney is that with durable power of attorney, that only lasts through life. The moment you pass away, that's done. So if they had durable power of attorney during life, great, they'll make decisions, but once you pass, they can't. Living trusts, those are awesome because it lets a successor trustee take over and make those decisions for you. It helps a lot that way. So then you have to ask the question, what happens if you die without an estate plan? Well, some property passes automatically to joint owners, and that's why we talked about joint ownership in that and titling things properly. Additionally, if you have a retirement plan, they have designated beneficiaries, so you've got somebody that it'll go to that way. But all other property generally just passes according to the intestacy laws of the state. Now, if you look at the next idea or the next slide, I have a little piece here that kind of gives you an idea of what that looks like. A typical intestate distribution pattern looks exactly like this. You may have a husband and father who passes away. Well, he has 2 children. Typically, the way it would work is half would go to the wife and then a quarter to each child. Typically. In Kansas, that's typically how it works. Other states have different laws, though. So that's why it's important if you have property in other states that you understand this, because it may not go the way you think. You may think, well, I have a will, and so it'll go that way, but then the other state might not recognize the will that you have, or it may go a different direction. So you make sure you have to have all that stuff buttoned up properly. And that's where we come in. Come talk to us, and we can direct you to the right places and people to get that relationship that you need so that you can have a plan in place.
Just make sure everybody understands that. If I have let's say a plumbing business that's got a little bit of, has some value to it, and it's just in my name only, and I pass away, the court is going, my wife now owns that plumbing business with my 2-year-old child.
Yeah.
So, nice business partner.
Yeah, that's a good point, because it's exactly right. When it goes through those intestacy laws, your actual wishes are irrelevant. It's whatever the law says is going to happen.
You don't have it written down, it does not count. It doesn't matter.
Right, right.